Welcome back to If You Can Keep It, a podcast created by the Wisconsin Institute for Law and Liberty. We hope you had a great 4th of July. You got Pat Garrett, Communications Director here at Will, and Rick Essenberg, President and General Counsel at the Wisconsin Institute for Law and Liberty. We're here to break down what was a pretty, you could say tumultuous, you can say impactful Supreme Court term. And June is kind of the official end of all of that. And so we have a number of rulings that we're going to break down. It covered a lot of different topics. We're going to get to as many of these rulings as we can, but we're going to start with some of these that will make a bigger impact and maybe affect some of the litigation we do here at Will. So, Rick, welcome back. Happy 4th of July.
Thanks for having me.
As you know, a number of things kind of happened in June that we want to dive into. And I think before the episode, you and I were talking, and you kind of summed it up pretty well. Like the cultural left really had a lot of things not go their way. There was a number of cases, and I think we start with Mahmoud v. Taylor, but let's jump into it.
Yeah, the cultural left had a bad June in that there were a series of cases which I think undercut some of their foundational premises. Now, Mahmoud was one of them, and Mahmoud is a case where the question was school district has got curriculum for elementary school children that celebrates same-sex marriage, celebrates gender transition, tells kids that the doctor and your parents are only able to guess at your gender when you're born, and sometimes they're wrong. Parents object to that. Ask not that the program be eliminated, but that their children be permitted to opt out of that curriculum, that they be told when that's going to happen, when that material is going to be presented in the classroom, and that their kids get to opt out. School says no. Litigation ensues and goes up to the United States Supreme Court, with the parents arguing that their religious free exercise is being impaired by this because this curriculum is actively interfering with the religious upbringing of their children. And by 6-3, the court says an opt-out is required under these circumstances, is a violation of the parents' free exercise rights. And, on the one hand, I think the majority opinion is a very significant sea change or at least potentially a sea change in the way that the court views impairment on religious free exercise. Traditionally, the court has sort of seen secularism as the baseline. And so if you depart from that, if you have, for example, a non-denominational prayer at a graduation, this is a violation of the religion clauses. But yet, if you have curricular material which undermines or contradicts the religious tenets of students, that's just fine, right? That doesn't raise religion clause problems. And here the court, I think, abandoned. So that's kind of an asymmetrical neutrality if you think about it, right? I mean, I had a law review article I want to write years ago, and I hypothesized, you sort of using the old Dick and Jane readers. You have to. Our older listeners may remember some of those from the 1960s, and they were the two characters in the elementary reader, and I said, imagine Dick is his family is an atheist, and he's an atheist, a family's atheist, and he can object to this very bland prayer, whereas Jane, whose family is evangelical Christians, cannot object to something which fundamentally contradicts their religious worldview. I think the court abandoned that uneven view where Dick can object and Jane can't, and it allowed these parents to assert religious free exercise claims. And you see in the dissent that they thought that this was preposterous, that because in their view, no one could really challenge these propositions that, validating same-sex marriage, validating gender transition, and they thought that this undermined one of the principal roles of public education, which is basically to teach everybody to have a certain set of ideas about these things. And so that undercut this premise of the cultural left that this set of views about human sexuality and transgenderism is something that we all should agree upon.
Well, and I think what was so interesting about this case is it is in a lot of ways a monumental win for parental rights. And we had some of our attorneys talk with, whether that's the Moms for Liberty group or other groups about just what this ruling means. Surely it might mean more, litigation in this area from organizations like ours. But this was also, this is such a relatively new concept. I think this concept of parental rights, years ago, I think 2019, pre-COVID, we just never would have seen, like you said, that change in the perception and the balance.
Yeah, well, I mean, I would agree and disagree. So we just recently had the 100th anniversary of Pierce versus Society of Sisters, which was a case which is generally attributed with first recognizing this parental right to control children's religious upbringing, and said that they could not be compelled to attend a secular public school. But you're right in that there haven't been a lot of cases, and even this case, even Mahmoud, was not a parental rights case. It was a religious free exercise case. It was there because the parents made a religious claim about this curriculum. But it's an open question. If it's a pure parental rights claim, right? If it's just, I just don't want my kid to learn that, not for religious reasons, but because I think it's wrong in some way, will that family have a claim? My guess is not, but we don't know that. The other important thing is that there's no reason to think that this is limited to issues, to LGBTQ issues, right? It could involve other things that conflict with a family's religious upbringing. And the third thing to keep in mind is that the defense said, well, what are you complaining about? We're not asking you to affirm these things. You're just being exposed to it. The majority said, well, yeah, but you're exposing elementary school children who are very likely to uncritically accept whatever their teacher tells them.
Because the schools are seen as the authority figure in a child's upbringing in some context.
Particularly at that age.
Yes.
And so Justice Scalia said, well, you have to have this sort of contextual analysis to see, to what degree this undermines the religious upbringing of children. And we'll have to see how that plays itself out in other contexts where the issue perhaps isn't as stark as it was here.
Well, I for religious purposes as well, we saw the Catholic Charities Bureau v. Wisconsin Labor and Industry Review Commission as well. This was I believe, a unanimous decision in front of SCOTUS, and it was a reversal of the Wisconsin Supreme Court's decision. And it basically, you're the expert.
Right. So I mean, this is a case that came out of Wisconsin. The Catholic Charities in this instance is Catholic Charities of Superior. And the issue here was Wisconsin's unemployment compensation law imposes a tax on employers. And this funds unemployment benefits for individuals who are laid off. And there's an exception. This tax is not imposed on employers operated by a church for religious purposes. And Catholic Charities says that applies to us. Now, Catholic Charities wasn't saying, our employees don't get benefits if they're laid off. They had their own private system that they funded that would be available for use by their employees. And so the question became, everybody agreed that Catholic Charities is run by a church. It's run by the archdiocese there. And then the question is it for religious purposes? And the way that the Court of Appeals in Wisconsin and then the Wisconsin Supreme Court, they wanted to draw a distinction between religious activities and religious motivation. And for Catholic Charities, that was a false distinction. The Wisconsin Supreme Court says, well, we don't think it's religious purposes because the services that are provided by Catholic Charities are available to anybody. They don't have to be Catholic, and there's no proselytization that comes on. They don't try to convert the people who receive their services to Catholicism. And Catholic Charities' response to that was, you're absolutely right, we don't limit it to Catholics. You're absolutely right, we don't make their acceptance of the faith as a condition of receiving help, because our faith commands us otherwise. We believe that we're called by Christ to do this without regard to the religious beliefs of the people that we help, and that is our religious obligation. And the Wisconsin Supreme Court was effectively telling them, no, it's not.
Well, and so if you're on the left, you might make the argument that religion by the Supreme Court of the United States is now basically being prioritized. What would you say to that? Would you say that, we're abandoning separation of church and state? It seems like, what if there's a cross in the classroom? I think you brought up that question may very well come up at some point. Like, what can someone object? Can an atheist object?
Well, they might. I mean, I think they still can under existing law. I mean, if you talk about prioritizing religion, to some extent, the religion clauses do that. They identify religion as a special thing in the life of people. And so, I don't have a constitutional right to be a Republican or a Democrat. I do have a constitutional right to be a Catholic or a Jew or whatever I happen to be. And so, in that sense, religion is privilege. Now, you have these two constitutional commands. One is people have the right to free exercise of their religion. The state can't establish a religion. And so what does it mean to establish a religion? Now, one might make an argument. I'm not, at the end of the day, convinced by this argument, but I think the case law would support it at this point still, is if you have a crucifix in the classroom, that constitutes an establishment of religion, and that you ought not to be able to do that. But that is a different question as to whether or not, if the legislature decides to give an exception to a religious organization from a tax, like, for example, churches don't pay taxes.
Correct.
Of any kind. Well, they might pay user fees. That's a different question than whether or not in a public setting to put a crucifix on the wall might convey a message that the state favors this particular religion.
Well, I don't think we've had because I just want to stay on the cross for the wall for a second. Like, I don't think we've had a case to that level rise to the Supreme Court yet.
We've had cases in the Supreme Court about religious expression in public places. We've had a lot of them. We've had cases about Ten Commandments, and they've been kind of reached confused results.
Okay.
So we've had questions about prayer in school. So we've had all of that, and as I mentioned earlier, the court has tended to see secularism as the baseline, right? So if there's a departure from that, which seems to favor religion, the court has generally found that to be constitutionally problematic. My point is that it has, it has adopted a rule that if you have some kind of religious expression at a graduation, if you put the Ten Commandments on a wall of a classroom, that can be seen as endorsement of religion, and that's problematic constitutionally. But it doesn't follow the same rule when the school does something which is antithetical to religion, like the parents in Mahmoud claimed was the case with this curriculum about same-sex marriage and gender transition. And I think that Mahmoud represents a number of things, but it represents, I think, a step back away from that dichotomy, that unequal treatment by the United States Supreme Court. But it's going to bring up other questions down the line, because does that mean that any student can be has a right to opt out of anything which can be thought to be inconsistent with their religious views? And this has always been a dilemma when we sort of consider the scope of the religion clauses, because religion can be almost anything, right? It's limited really only by human imagination. It might not be right, but there are people that might nevertheless have that sincere belief. And so there's a lot of concern about line drawing that goes on. So, does Mahmoud mean that, let's say a Muslim student who went to class and there was a classroom session that, talked about, the emancipation of women and, the value of women in the workplace and that type of thing. And, his parents tell him religiously they don't believe in any of that stuff. Does that person get an opt-out? How does the court deal with that? Those are the kind of questions that are going to come up down the road.
We spent a little bit of time on the religious angle, and I wanted to make sure that we still touch on kind of two other important cases that we didn't get to. Trump v. Casa, which covers birthright citizenship, but mainly it covers the preliminary injunctions that have been, or maybe these nationwide injunctions. A preliminary injunction is due justice.
So there was a footnote in which Justice Barrett discusses that, what to call this. She says it's not really a nationwide injunction because there could be a nationwide injunction, but this is more of a universal injunction. And what she's getting at is this. So a lot of times, particularly on social media, people will say, why doesn't Will go to court and get the court to declare this particular action by the government is unconstitutional?
We get this question all the time.
Right.
All the time.
And my response is, well, you can't just go to court and say, issue a proclamation. You have to have a client. The client has to be injured by this in some way so that they have standing. They have to have a cause of action. There's all sorts of, because courts don't make proclamations about the law. They decide cases. Now, in the course of deciding those cases, they will clarify the law. They will say what it means, and that creates precedent that will be followed elsewhere. Now, in the case of injunctions, that is an exercise of what is often called the equitable jurisdiction. We say it's an action in equity where we're not giving money to somebody. We are preventing somebody. We're ordering somebody to stop doing something or to start doing something. And so the question is, can a court issue such an order that applies to people that are not before it? So in this case, what Justice Barrett did is she went back to the Judiciary Act of 1789, which grants equitable powers to federal courts, and she says, well, was a universal injunction one that applies to everybody, even people that didn't come to court? Was that contemplated? Was that frequent in equity jurisprudence in 1789? She says it's not. In fact, these universal injunctions haven't become frequent really until the first part of the 21st century.
Well, and that's also been a huge line of criticism of the judicial system from the more MAGA conservative folks online, though. You could see the memes, a district court has ordered Trump to rebuild the Iranian nuclear plants.
Well,
this joke keeps coming back and back and back. And so, it's clearly on everybody's mind.
Right. And was during the Biden administration, but it was flipped, right? Depends on whose ox is being gored, because then it was the folks on the left that didn't like these universal injunctions. Because, an example is a case that Will had, where, we had the Biden administration had a program that was handing out uh, uh, relief funds, COVID relief funds, on the basis of race to restaurants. And we had a client who was ineligible because although his business was minority owned, it was only half minority owned, his wife, but she only had 50%. So we didn't qualify. And so he went to court saying that this violates my constitutional rights. You're denying me this benefit on the basis of race. We ultimately won that case in the Sixth Circuit Court of Appeals and got an injunction. Now, you can imagine an injunction like that going in two different ways. One would be, okay, we're going to give Mr. Vitolo his government benefits, but other than that, the government can continue to go on the way it's going on. Or we can say, government, you can't give money based upon race to anybody, including people who are not here. And that would be, you can make an argument that in that instance, perhaps a universal injunction would be appropriate because it would be necessary to accord complete relief. I don't know that that would work, but that's the distinction that is going on here. And the criticism of the decision in Casas has been that, doesn't this make it impossible, nearly impossible, to validate constitutional rights because everybody is going to have to bring their own separate case? And the response of the majority was, well, no, because sometimes an injunction that applies to everybody will be the only way to accord universal relief because the government can't pick and choose between people that are going to be subject to its action and who aren't. I mean, it's just not practical. Or you can bring a class action. Class action is when a lawyer comes in and representatives stand in for a class of people who are similarly situated and similarly treated. And you can get class relief. And that is provided for in the federal rules. Or perhaps you can, under the Administrative Procedure Act, if you have something that's subject to the APA, like you can challenge that and get that set aside. So there are ways to go about it. Or if the case goes up to the United States Supreme Court and the United States Supreme Court rules, then that's going to be precedent. And yes, the government could keep asking every individual litigant to come to court and challenge this. In each case, the Supreme Court precedent is going to be applied. The government is going to lose. At some point, the government is going to get sanctioned for doing that. I think that that's a scenario which is present more in theory than in fact. It's probably not going to happen. Having said all of that, I think that it would be appropriate for Congress to provide for universal injunctions in some circumstances with expedited review, because I think sometimes you need them. But the problem that you don't want is there are hundreds of district court judges in the United States. You don't want some district court judge coming in and stopping a national program based upon of his or her own individual view of the law, which may not be correct and is going to be subject to 2 layers of subsequent review, both at the Court of Appeals and the Supreme Court, and with respect to which other district judges may not agree. You don't want to give one individual judge that much power.
I think I saw something. I thought Senator Grassley had a bill to govern these types of injunctions. I mean, I think you could make the argument that what's made our courts so politicized, and I'm kind of bringing this up just based on what you said, what's made our courts so politicized is in some ways Congress has abdicated its responsibility to provide some direction as to what's going on any given day, on any given issue.
Right. I mean, Congress is sort of AWOL. It's very difficult to get anything through Congress, but Congress has in the past both limited and expanded the jurisdiction of federal courts. There's an interplay with the Constitution as to whether they can do that. But there are all sorts of proposals that have been forwarded to deal with this, and Congress could enact one of them.
Okay. Well, so Rick, one of the things that I think has just played out here is this over politicization of the court. And if you go on Twitter, and depending on who you talk to, it's now X, whatever, is it, you could talk to MAGA people who are upset at Amy Coney Barrett on any given day, or they're upset at John Roberts on any given day. You can talk to the people on the left who think that the court has just, lost its mind. I mean, so my question for you is the Roberts court, is it a resistance court or is it a MAGA court?
Well, it's neither. I think so. When Trump was running in 2016, one of the arguments that you get is we got to vote for Trump because Trump has promised to nominate off this list of Supreme Court justices.
It was a good list, was it not?
And they'll be great. It was a great list. And that was a pretty good argument.
Did it work on you at the time?
But it did. And but I used to joke and say, okay, but let's just be clear on this. He's going to want to nominate these good conservative constitutionalist judges until he finds out that they won't let him do whatever he wants to do. And when that happens, he will react badly to it.
Do you think, I think I know the answer to the question, but we're just going to ask it. Does the judiciary, does the Supreme Court, the Roberts Court, or let's say he balks and it's a 5-4, do they let him do whatever he wants?
No. And that's exactly what happened, right? So he lost some cases during Trump 1.0. But the thing that I think really grieved him was, that there was this, case that wanted to sort of reopen the appointment of the electors, and he lost. He got blown out in that case. And so, we had the tweet just recently where, he attacked Leonard Leo, called him a sleazebag, Leonard Leo being the former vice president of the Federalist Society and a guy who was very involved in the picking of judges during Trump 1.0, said he didn't like all these Federalist Society type lawyers, which basically means like people like the lawyers at will.
Well, and you're part of the Federalist Society. We're close
and the Federalist Society. I always say the Federalist Society has been very, very good to me. And so obviously they've gone against him enough to get him annoyed, and we've seen the attacks. We've seen attacks on Kavanaugh. We've seen attacks on Gorsuch. We've seen attacks on Roberts, Amy Coney Barrett, because sometimes they have ruled against him. Most recently, I think, in the area of due process rights for deportation. All 9 justices of the United States Supreme Court said in April that you have to accord due process rights to people who are being deported, right? And the Trump administration had said, no, we don't necessarily have to do that because they're illegal. Now, it's a very poor argument because it begs the question. One of the reasons that we have to have due process rights is so we can make sure that the people who are being deported are actually deportable, right? That's what due process means. It doesn't necessarily have to be a trial. It doesn't have to go on for years, but they have to have notice, opportunity to be heard, and raise objections to their deportation. So, they've ruled against him. They've ruled for him. That's what you'd expect a constitutionalist court to do because, I don't think the Trump administration, like the Biden administration before, always prioritized the limitations of the Constitution over their policy preferences. They don't do that.
Well, it's what you said a long time ago too. We get too upset over the president and who wins that presidential election, and it's because the president has taken on far too much power for themselves.
Right,
and it's not a Trump thing. It's not a Biden thing.
In a debate that we're having, so Trump has argued for this unitary executive, which basically means that Trump should be able to control all the various aspects of the executive branch in performing executive functions. And I think with respect to that, he's right. If he doesn't like the way USAID is exercising its discretion with respect to the disbursement of funds, he can make them do something different because he's the boss. But there's a difference between the unitary executive and the imperial executive, which means that, the president can ignore Congress or ignore the courts, or the president can make law himself or herself. That's not permitted. So, if the Congress passes a law that says, we want you to, spend $50 million on a transgender opera in Guatemala, I think that's a bad idea. It's a bad use of money. But if Congress has done that, then the executive branch has to administer the law that Congress has passed. And so you can see under those circumstances that a constitutionalist court is going to be coming to different conclusions based upon, different facts and circumstances, and is not going to approach cases because it's either, pro-Trump or anti-Trump. So I would say even the conservatives on the court, they are neither resistance or MAGA. They are constitutionally conservative, a majority, and that can yield results sometimes that go in different directions.
Well, before we wrap up, we like to hit you with an off the cuff segment. So we kind of have two questions for you. This first question is, think back in the Supreme Court, any justice from the last 50 years who served. They could be sitting there right now, or they could be gone. It could be a liberal, it could be a conservative. Who on that court has been a big disappointment, and maybe why?
I think Anthony Kennedy was a big disappointment.
Okay,
I think the reason for that, I think Anthony Kennedy had some good instincts, but I think he became too enamored of the fact that it was his role to just sort of dispense unguided wisdom. And, I was just talking to somebody yesterday who was, last week actually, who was, explaining her view of the judicial role. And I said, well, tell me, why do you have to have an overarching judicial philosophy? Why can't you just do what's right? And she said, and I think put it well, that the reason is that your job is to follow the law and not simply impose your view of the way things should be, because you haven't been selected to do that.
Yes.
And in a democracy, you don't, as a judge, have that kind of power. And having a philosophy like textualist or originalist, it's not going to answer every question. It's not going to make the process easy or simple or automatic, but it's at least going to keep you focused on what it is that you're trying to do. And I think there were times when Justice Kennedy lost track of that.
Fair enough. So here's the last question. There's a couple caveats to this one. If you could put somebody on the Supreme Court tomorrow, it cannot be yourself. It cannot be anybody who works at the Wisconsin Institute for Law and Liberty. Those are obvious choices, so we can't go there. And it can't be Senator Ted Cruz. Who would you pick?
Well, that is...
Did we stump you? I think we might have.
An interesting question. Well, no, you didn't stump me. There's all sorts of possibilities. So I'm going to go outside the box, and he would never get nominated because he's too old. But I think it would be very, very interesting to have Randy Barnett on the court. He's a law professor at Georgetown, a little bit more on the libertarian side. I think he would bring a perspective to the court that's not there.
Well, thanks everyone for tuning in. We hope to have you back next week. While this episode really covered the Supreme Court, the Wisconsin Supreme Court has wrapped up a season on its own with a number of rulings that will impact, lives here in Wisconsin. But as Wisconsin goes, often the country goes, and so we're going to break some of that stuff down over the next couple of episodes as well. And Rick's going to be joining us, and maybe a couple other attorneys at Will who have really followed these more Wisconsin cases. We have a nice little webpage for this podcast at will-law.org/podcast. You can find our full schedule of episodes, and we look forward to seeing you next week.